Members of Parliament, support staff, radio listeners, TV viewers, all following this meeting via social media, members of the media, ladies and gentlemen, good morning. I welcome you to this public meeting of Parliament. It is public meeting number 10 for today, Wednesday, February the 19th. At this time, I wish to give a special welcome to the Minister of Public Housing, Spatial Planning, Environment and Infrastructure, Mr. Patrice Gomes Jr. and his entire support staff here present. We have established a quorum of 10 members. I invite you to stand for a moment of silence. Thank you. I have received notice of absence from the members of Parliament Doran, Kotai, and Roseburg. I have received notice of lateness from the member Otley, and I ask if there are any notifications from the floor at this time. I don't see that being necessary. Before we continue, do allow me on behalf of Parliament to express condolences to the mother, family, and friends of the late Donellis Brown. Donellis was a young journalist who worked for many years here on St. Martin after having grown up here on St. Martin. So again, I want to take this opportunity on behalf of the Parliament of St. Martin to extend condolences to the ones he left behind and to all other persons who are mourning the loss of a loved one. On behalf of the Parliament, we extend our sincerest condolences. We now continue with the agenda point for this public meeting, and that is deliberations with the Minister of VROMI regarding the status of the draft policy on the land issue. This is actually a request from several years ago. However, the issue of land policy, etc., and issues relating to the land policy of government are still very actual, and thus the meeting today. As I mentioned, it was several years ago, in fact, on February 4th, 2022, that Parliament received a letter from some of the then MPs, MP Gomes, MP Peterson, a current MP, Sarah Westcott-Williams, another current MP, Lutmila De Weaver, with a request that a meeting be convened to discuss, one, the status of the over-the-bank case with regards to resolution number 2 and resolution number 4 of the Peterson motion, and in consideration of the court case with verdict dated the 28th of January 2022 regarding the same over-the-bank land. And secondly, the status of the draft policy on land issue as it relates to the recommendations that appeared in the court verdict of the 28th of January 2022. Members of Parliament, this is a document registered on the 531 of the Parliamentary year 21-22, and it is dated February the 4th of 2022. The presence of the Minister of Public Housing, Spatial Planning, Environment and Infrastructure, VROMI, was also requested, and the draft policy issuance domain land was received by Parliament on February the 2nd of 2022. That document, members of Parliament, is registered on the IS 516 of February the 2nd, 2022. This meeting was initially called and it commenced on Wednesday, February the 23rd of 2022 as a public meeting number 9 of the parliamentary year 21-22, but it could not continue due to the lack of a quorum at the time, and the meeting was never reconvened after that. As I mentioned during the introduction, the importance of the topic and several developments surrounding the topic of land issue here on St. Martin, it's still important that we have this discussion, and we probably will be getting an update as far as these matters are concerned from the minister. We also recall
Good morning, Madam Chair, members of Parliament, radio listeners and viewers. Not the most elegant beginning, but we are here. Allow me as well to begin by echoing my condolences to the Brown as well as the Choisy family for their losses. And I'd like to begin again the presentation on land issuance and land pricing policy. Very brief presentation because I think I would like, of course, to leave a lot of room open for deliberation, discussion, and a way forward. What we've done, my team and I, is to begin by offering first a brief background. Second, was indicated by MP by Scott Williams, a brief introduction of the DDAM arrest, what it actually is, why a land policy, and finally, country package E7. And of course, toward the end, as we go into our questions, I will go back to introduce my colleagues as well, who I unfortunately began this presentation without mentioning. Background. October 2021, PFP MPs, so Party for Progress MPs, submitted a motion calling for a formal land issuance policy by December 1st, 2021. The motion proposed a halt on land allocations in Vineyard Heights and addressing issues with previous applicants. Parliamentary discussions were cut short, preventing meaningful debate on the motion's resolutions. On January 2022, there was a court ruling that ordered the Minister of VROMI to cease long lease land issuances in Vineyard Heights. Finally, the court ruling reinforced the urgency of implementing a transparent and structured land issuance policy. DDAM arrest. Now, the team and I decided that it's very important to spend some time exploring what exactly DDAM is for one simple reason, is because despite it being in place, a number of persons are still approaching the ministry, myself, and government as a whole regarding requests to actually have a piece of land or to deed their land. And with the presentation, you'll now realize that, unfortunately, that is not possible. So we begin very quickly. In the DDAM arrest, it was ruled that the government must establish strict legal requirements for the handling of land transactions to ensure the principle of equality, transparency, and fairness. And there were two rulings on this case, the first, November 2021 and November 26, 2021, and a follow-up on November 15, 2024. The core principles from these rulings are as follows. Mandatory transparency and competition. Government bodies cannot freely sell, lease, or allocate land without publicly announcing their intentions in advance. If multiple parties exist or could reasonably be expected to be interested, the government must allow them to participate in a fair selection process based on objective, verifiable, and reasonable criteria. 2, strict conditions for exclusive lease or sale. An exception applies only when it is objectively certain that there is only one serious candidate who uniquely qualifies. In such cases, the government must publicly justify why no other party could reasonably qualify before proceeding with the transaction. A mere assumption or informal agreement is not sufficient. The third core principle from this ruling, legal consequences for non-compliance. Failure to comply does not automatically void a contract, but it constitutes unlawful conduct by the government. This means that excluded parties may challenge the transaction in court. If the sale or lease has not yet been finalized, the court can prohibit the government from proceeding. However, if the transaction has already been fully executed, in principle, the sale remains legally valid. An excluded party may seek financial compensation for damages. These rulings impose strict compliance obligations on public bodies, including the government of St. Martin, reinforcing the need for transparent procedures, public announcements, and fair selection criteria in all land transactions. So what are the implications for St. Martin? These rulings directly affect how the government of St. Martin, and specifically the Ministry of VROMI, must handle public land transactions. The government is now legally obligated to ensure all land transactions are transparent and publicly announced well in advance, ensuring that interested parties have a fair chance of obtaining the lease or sale. Define and publish clear selection criteria before allocating land. Thirdly, justify any decision to sell or lease land to a single party with objective, legally sound reasoning. Avoid informal or indirect allocations without proper public procedures. And finally, we are then and thus obligated to develop a formal policy that aligns with the DDAM criteria, ensuring that all land transactions follow a legally sound and transparent process. This policy must provide a clear framework for public announcements, selection procedures, and justifications for exclusivity to minimize legal risks. As a government, we must ensure that land, a scarce and valuable public resource, is managed in the best interest of the people of St. Martin. These rulings reinforce the need for fair, transparent, and accountable governance in all land allocations. So why a land policy? As I stated before, transparent and fair distribution of land. One second, Madam Chair. Based on clear and consistent steps in the policy, everyone goes through the same exact process when applying for land and will be assessed equally based on the same criteria. Additionally, the processing of the request will also strictly comply with the processing steps as described by the policy. Secondly, why a land policy? Guaranteeing social equality. Based on the policy, we ensure that all socioeconomic levels in society are treated equally, and no one gets preference over the other. Only in very specific cases and in view of general interest for the country, exemptions or other rules will apply. For instance, if the land will be used for social housing development. Preventing uncontrolled urban growth. Without a land policy, urban growth happens uncontrolled and chaotically. With a land policy, we can better control, regulate which land use purposes are allowed in which areas. Creating a balance between tourist and local needs. And you realize very quickly, Madam Chair, through you, that a lot of the need to have a land rental agreement or a land lease agreement also ties in very closely to the idea of zoning. Hence a number of the points that you see here as to why a land policy. Tourism, our main source of income, but the lack of a focused land policy can lead to an imbalance between tourism development and local needs. If there is no balanced approach, this can result in excessive emphasis on tourism infrastructure and services, compromising the interests of local people and sustainability. Protecting the environment and sustainable use of natural resources and preventing ecological damage. Without a policy, destruction to ecological valuable areas such as natural areas, coastal areas, and biodiversity hotspots is more likely to occur. Viable areas such as protected natural areas, coastal zones, and habitats. Uncontrolled development can lead to a loss of diversity, destruction of natural ecosystems, and a damage to critical habitats. And finally, protecting cultural heritage and identity. Uncontrolled development can also lead to the loss of cultural heritage and identity of local people. If there's no land policy to ensure the protection and preservation of culturally significant areas, the traditional way of life and cultural heritage of the community can be lost. So we finally come to Country Package E7. This is actually an agreement between St. Martin and the Netherlands for a number of interventions necessary to receive a number of loans post the COVID-19 pandemic. Country Package E7 deals specifically with the Ministry of VROMI, and the terms of reference is published as is. VROMI is executing 3 projects under E7, of which the land issuance and land pricing policy, as indicated, is one of them. A terms of reference has been published for the 3rd time recently. The first time was December 9, 2024. The second time, January 22, 2025, to hire a project manager for the execution of this project. The closing for applications, February 22nd. The reason, of course, for the 3rd time publishing this is because we have had some challenges in terms of soliciting interest in actually handling this project. The timeline, of course, is as soon as we hire a project manager, the timeline to make this policy is exactly 1 year. So, as we see with the challenges of finding someone interested to actually make this policy, we actually are slightly pushing our timeline further and further. But, of course, to mitigate any further delays, we have, of course, started internally working on an interim policy. I think we have also pulled what we could from the MP Duran, former Minister of VROMI's proposal that he proposed back in 2022 or 3, I believe, with some key steps that could be taken to establish a land lease policy. A number of other things too, when speaking with the consultant, indications about not necessarily looking within only the kingdom, but given St. Martin's unique situation, looking as well within the other islands. So we've been looking as well at the policy for the British Virgin Islands regarding Crown land, as well as St. Kitts and Nevis and St. Lucia. Finally, moving forward, the Ministry of VROMI will implement strict compliance measures and establish a formal land allocation policy to uphold the legal standards and protect the integrity of our land management process. I'd like to also clarify that DDAM, as stated in several meetings that I've had with Parliament, is strictly about the issuance of new land. Persons are still allowed to transfer, have extensions, and also to renew existing policies. With that, Madam Chair, I come to the end of my presentation. I thank the honourable members and look forward to their questions.
Thank you, Minister Gums, for that presentation. The members of Parliament, of course, if you wish to speak in this public meeting, you would have to sign the speakers list. At this time, I don't have anyone yet indicating the need to speak. I see MP De Weaver would probably indicate that need, so I await MP De Weaver's signing of the speaker's sheet, and then I will give her the word. MP De Weaver, you have the floor. Just a reminder, the speaking time, of course, for the members of Parliament is 20 minutes in the first round and 10 minutes in the second round. So with that, MP De Weaver, I give you the floor.
Thank you, Chair Lady. Good morning to you, my colleagues, the Minister and his team, support staff, everyone listening or viewing. Minister, actually, every time I had a question based on the Minister's presentation, he answered it subsequently. So the only thing I need to ask is, listening to the presentation and a couple of the comments you added in, I made notice of, for instance, land policy where it's going to have I feel like maybe it may potentially have an all-encompassing effect covering other ministries where, for instance, if it's done completely, that means it could also potentially include protection of monuments and certain land areas then, I guess, which means that it will, private property. But then it will also restrict certain tourism, construction development based on what I hear. So it was very, very brief in an additional comment. So I just want to know if this has the potential of actually be far reaching, because one of the challenges that we've had here when you look at everything separate is when you feel like you have a protected area, something happens to it, because whatever process has to be done to protect something didn't take place. And then if we're talking about exactly the comment that you said of we may have sort of reached capacity on certain projects, that also will have an effect on it. So we're touching now already Education, Culture, Youth and Sports Ministry, as well as Tourism, Economic Affairs, Transportation and Telecommunication Ministry. If that is the intention, then what is the dialogue that's happening with the other ministries now on it? Is there any sort of authority that needs to come over your direction? Because for me, I feel like it should be an all-in-one package. That way we don't have this constant back and forth on cultural heritage, on our tourism plan for the future. Thank you very much, Madam Chair Lady.
Thank you, MP De Weaver. I look at the speakers list, and I now give the floor to MP La Vega. MP La Vega, you have the floor.
Good afternoon, good afternoon. Sorry, good morning.
Morning.
Good morning. What time is it? 23 minutes left. Good morning, Madam Chair. Good morning to the Scroffier, my fellow colleagues, and good morning to the Minister of VROMI and support staff. I'm very happy to hear that finally there's going to be a land policy. I know this has been a hot topic for many years, maybe even a decade, where ministers have the discretion to give out land to who they want, when they want, and even some of the time, the time when they allocate the land is very suspicious, and it definitely goes against some of the major plans that governments have. I would even go as far as prioritizing the people in society with lower socioeconomical status, because I believe that everybody should have a fair chance to acquire land and fulfill their dreams of home ownership. So I'm very glad that this is now in play. I have a few more questions as the presentation and the dialogue continue, but I'm very glad to hear this is finally here. Thank you.
Thank you, MP La Vega. Members of Parliament, is there no other member who wishes to speak to the topic? I see MP Jansen-Webster is... MP Jansen, you have the floor.
Thank you, Madam Chair. To the Minister, good morning to everyone, to colleagues, and welcome to the Minister and his support staff. Through you, Madam Chair, to the Minister, I just had one burning question regarding land allocation. Just if the Minister could take into consideration, instead of giving 2,000 square meters, for instance, to one household, if we could look at bundling 3 parcels of 2,000 and then creating a space, or even using the 2,000 to create a space to have the social housing that we so desperately need. You know, so maybe look at it a little different, where more people can make use of the small amount of property that is still available. That's just an observation. If, through you, Madam Chair, if the Minister can also look at that when allocating land. Thank you.
Thank you, MP Jansen-Webster. And I now have MP Lyndon Lewis. MP Lewis, you have the floor.
Good afternoon, Chair. Good afternoon, Honorable Minister and your support staff. Good afternoon to my colleagues, members in the Tribune. Good afternoon, St. Martin. Minister, I only have one question with regards to the policy when it comes to implementing procedures on how an applicant should apply. I know you mentioned about first going public with your intention, but many individuals, for example, over the years have applied for long lease land. They never received an answer. I think it is respectful that individuals get an answer, whether they are going to get it or if there's no long lease land or pertaining to the zoning where they're looking for property. Many are still awaiting answers or response from your ministry as to what is going on for many years. As I know, for example, in the Ministry of TIAT, if you apply for a taxi license, there is a moratorium. They will receive a response that there's a moratorium. If the moratorium is lifted, then they have the opportunity to apply again, and their chances are there 50-50. But is there any way within the policy that if one applies for property, what is the time frame for them to receive a response whether or not they can obtain long lease land? That is my question. Thank you.
Thank you, MP Lewis. I see MP La Cruz taking or requesting the floor by signing the speakers list, so I give him a minute or two. MP La Cruz, you have the floor.
A blessed morning, Madam Chair, Lady Griffier, Minister, Honorable Minister of VROMI, his support staff, my colleagues, those listening through social media. Madam Chair, Lady, through you to the Minister, a question that someone just sent me, and it referred a little to what my colleague just mentioned. If when this new policy is in place, the people that already have requested, do they still, or is their request still active in the system? Or will they have to reapply or re-request to be able to get a piece of government land? That is extremely important because there's, I think, a lot of requests pending in the system. And like my colleague just mentioned, it would be extremely important that they either get a reply or are told what to do and how to move forward, because that's one of the biggest frustrations that actually take place. Then, Madam Chair, Lady, through you, to the Minister, if the Minister could maybe in an infomercial or, just maybe on government webpage, put down how someone can request a piece of government land. A lot of times it's not about if they can, but just that they don't know how to go about with the whole process, and that creates frustration and a lot of misinterpretations where people would believe that, hey, I didn't get a fair chance, someone else got. So just ter informatie, that would be something that I would like to see in the short time ahead. Thank you, Madam Chair, Lady.
Thank you, MP La Cruz. I see the next member up to speak is MP York. I give the floor to you, MP York.
Thank you, Madam Chair. Good afternoon to the Minister. Good afternoon to support staff, members of Parliament, and those of the viewing public. Minister, I took note of your presentation, and the presentation has the timelines of actions passed, actions done up to date, and also that a third party will be executing basically the construction of the policy moving forward, and it should be done within a year's time. What I would have liked to see as well in the presentation, although a third party is going to put the policy together, it also comes with some directives from the Minister's Cabinet, through you, Madam Chair, of basically what the Minister would like also to be in it when it comes to directives and vision, right? And I did not get, because since the whole DNAM arrest and the whole issuance of making of a new policy, the public would also like to know what they can expect, right? So is there going to be a shift in vision with the way the land is allocated, also, of course, with transparency, but as well, what I was hoping for is that moving forward, not only issuing the land, but also that the government has, especially seeing that land is so scarce nowadays, and the movement forward when it comes to green spaces, social spaces, etc., that the government also incorporates a type of development plan for the land that's about to be issued, right? So although you issue one plot of land, that land is part of a bigger picture that's, once everything is developed, that it encompasses what the vision is of the government moving forward. So that way, you don't miss social spaces, you don't miss green spaces, you don't miss spaces, period. So my question is, what is the vision of the minister as it pertains to the way forward with the policy? I understand that he cannot give the details of it because he's not the one making it, but I know that his vision will be incorporated in it. So I think the people would like to have a bit of a richting, as you would say, of what they can expect of it, and within the year, also, if the minister will be coming back with various updates pertaining to the status of the policy moving forward. And that will be all. Thank you.
Thank you, MP York. I continue with the speakers, and I give the floor to MP Waver. MP Waver, you have the floor.
Good morning, Madam Chair, Griffier, Honorable Minister, support staff, honorable colleagues, those listening in the Tribune and via whichever media. You stated, Minister, through you, Madam Chair, in the country package, that there are 3 dates. So what happens, because you said there's also a lack of personnel or interested persons that would qualify for this position. What happens after February 22nd, after that deadline has been met, and we still do not have or found, let's say, the right person that we say, this is the one that's going to make sure that the project goes ahead? So that, and also the temporary policy, is that ready? And also, does the public know about it? How will how will pending requests be handled or informed? Do we still have CapEx available to purchase land? Because we know government land is scarce as it is, so we might have to look at acquiring private properties. So is CapEx available for those kind of purchases? Thank you, Madam Chair.
Thank you, MP Waver. That is it for now after MP Iran. MP Iran is signing the speakers list, so I give him a moment to do so. And then I give the floor to MP Iran. MP Iran, you have the floor.
Good morning, Madam Chair. Good morning, Griffier. Good morning, colleagues. Good morning to the Honorable Minister of VROMI and his support staff and the viewing public. Madam Chair, similar to the meeting we had the other day with the Education Ministry, I kind of feel like the government is coming to present items, but again, it's almost kind of pointless. Why are we sitting here today? Like, we're coming again to discuss the land policy. We know the issue with land policy. We had a whole motion regarding land policy. So what was the point of this meeting today? Like, what does the ministry expect from us as MPs? We don't have a solution. And going back, and it's hard for me not to go back a little bit, because this government, and I keep emphasizing on that, and this coalition, they love to go back and say the former administration, et cetera, et cetera. And when we look at what was said in the past, but a land policy was drafted. Seemingly it wasn't perfect, but it was done, and it was made to seem as if one could be drafted in 6 months, in a year, 2 years, and now today, the government is right there for more than 6 months, and the timeline going out is another year, basically. I have a lot more questions, but based on the information given, they're still in the research phase. They're still in the phase of of looking at the other islands. They're still in the phase of finding a third party. So a lot of questions that we might have today, they're still having to go and do research on. So I really don't see the point of having meetings from government to come and give us a report, but without a position or vision of government itself, because we've had these meetings already. I do have a question, though, in regarding something that we were looking at as a government back then, and also a potential extra revenue generating for this government. We looked at, well, it's a proposal that I brought forward to VROMI at that time. I said, hey guys, we have individuals also, yes, we have the DDAM situation, but we also have individuals that already have long lease land, especially around the lagoon, the pond area, among other areas. But what they've also done is continue to fill in, right? So they've continued to create value for themselves, but excluded government. So I said, hey guys, I think the department where the former minister worked, Mikolos, I forgot the name of his department, they had done a big project once with drones and actually knowing all where the land is. We said, listen, look at that land and let's tell the person, we don't want to take it back, but you have to pay because you now created more government land, lease land, but you're not paying for it, all right? So is that something the government can now look into that's separate from DDAM arrest, because these individuals already have the land, and again, I know the government needs money, so let's look into this because, like I said, it'll continue to happen. We need to know exactly how much extra land has been created, how much extra value has been created, and that has an economic value and money for government. What is the update? How many cases are now by the notaries? How many cases do we have at the notaries that of persons purchasing a property or trying to purchase or trying to have a transfer done that cannot be done? I know there are cases since we were there. So how many cases are you aware of currently of persons that cannot execute that transfer? And because I've heard of some cases where the government has executed with the notary, because I know I've seen cases where the notary were specific on certain individuals on saying that this is not part of DDAM, but then with other individuals, they're like, oh no, this is part of DDAM. So how are we justifying which one isn't? Or is it only based off of the notary's perception, or is it also the perception of what government believes on which person or entity is part of DDAM or not? If, with the data you have now already, what specific objective or criteria will be established for the allocation of long lease land in compliance with the DDAM ruling? Is there any updates, let's say, regarding the Vineyard Heights and that whole situation? MP York asked a question regarding government's plan in terms of, let's say, if we're giving out land, if we're going to set criteria for this specific area and say, listen, in our policy, it'll be specific to location. So not just a policy on how to give out land, but are we going to create a policy specific towards location? So this area we're going to say is for development, commercial only. There's other areas for more for housing. There's areas only for, let's say, green projects, so green space projects. So you could develop, but it has to be in line with green space projects. And the question was brought on CapEx. There is money on the budget now for CapEx. It's already 10 million. Is the policy going to include new land? So we had a meeting yesterday with Nature Foundation regarding putting money on the budget to buy property, to make it green. Would that policy also include that? So new land that's purchased that becomes government land, would it then go directly into the specific criteria in terms of, let's say, zoning? What is the minister's position or sentiments towards the country package? Okay. Do you see yourself within the current country packages, all related to VROMI? Is that, you know, in the past, we've had persons say, hey, that's the Holland, that's Dutch, what is government doing? I mean, I would say, when I was there, listen, we have adjusted our own, at least for the Ministry of Finance. This is our project, right? We're not doing things that we don't want to do. And some other ministers might have felt differently. So does the minister see himself in totality within the country packages? And do you believe that they benefit St. Martin? That'll be all, Madam Chair.
Thank you, MP Iran. I continue now, and I give the floor to MP Peterson. MP Peterson, you have the floor.
Thank you, Madam Chair. Still a good morning to yourself, to the Minister and his support staff, to my honorable colleagues, to the griffier and the Secretariat, and to everybody else joining us for this meeting. Madam Chair, I wanted to, also assist the Minister in explaining a little bit when it comes to the history of how we got to the DDAM arrest, because this meeting, as the Chair Lady explained in the beginning, this meeting was requested, I think, back in 2022, and it was basically as per the execution of the motion of disapproval that was passed. I think it was around the ending of 2021. So this is not the Minister coming to Parliament asking us assistance. This is the Minister following up on the accountability of the Ministry of VROMI according to the motions passed here in Parliament. Coming to the DDAM itself, I believe we've heard a lot today as to how we came to where we are now. And I must say, MP York echoed something that I wanted to bring forward as well, because we are seeing that we are going to outsource the making of the policy, which I can agree with because of the issues with domain. But then it brings me back to the crux of the problem. Within domain affairs, there is a position of policy advisor, and that person should take the lead when it comes to a project like this. Now, sadly, the last umpteen years, domain has been structurally understaffed. Therefore, the policy advisor, I believe one is sitting across the room, actually, as we speak, I'm one of the ex-policy advisors, and they can tell you that within domain, it was actually impossible to do policy because of the overload of work on the floor itself. So, and then that brings me back to my question, how far are we with Landspaket A Zeven? Because they have to basically pump some money into domain for us to get, a little bit more traction to work on the backlog. So an update on that through you, Madam Chair, from the Minister would be appreciated. And then I wanted to elucidate a little bit on the why when it comes to the DDAM arrest, because we see that a judge made a verdict, but we don't really sit back and understand how we reached to this point. And I can tell you, Madam Chair, it's because of nepotism. It's because of years and years, every Minister of VROMI coming and not issuing a policy, but thinking that because they're a Minister of VROMI, that justifies their personal choices in regards to who they issue land to. I believe in the last public meeting, I made it, I asked the Prime Minister, actually, since he is over Landsbesluiten, of a situation where when we got into office last year in May, we did some research, and I asked the Minister of General Affairs if it's normal for a sitting minister to basically machtig another minister that is not his plaatsvervanger, as per the vervangingsregeling, to just basically machtig another minister in a case of conflict of interest, and then to just sign for him. And I think that stuff like that is exactly why eventually the DDAM verdict came about, because that is exactly what the judge said. There is no transparency when it comes to the decisions that are being made, but the outcome is very clear. So I would like the Minister's sentiment on that exact topic as well, when it comes to the vervangingsregeling and his opinion on whether or not he feels that he can machtig another minister within the COM to sign for him in a case of conflict of interest, or if he thinks, and I also think as well, that maybe that should go to COM, because that is where actually the decision of that matter has to be made. Then it brings me back to the issue with the notaries, Madam Chair, because I don't think that a lot of persons understand what the issue is when it comes to the DDAM arrest. A minister can issue land. That is not the problem. The land can be issued. The judge simply said that if there is no policy in place that guarantees transparency and good governance, that the decision might be deemed unlawful. So that means that the notary, who has to basically sign every deed for long lease, they are the ones who are going to have to be responsible because they have a job as well as notaries. So let's say the minister now issues a piece of land, a piece of new long lease land. The person who received this piece of land, they can go to all three of the notaries, and they will tell you we are not deeding this because there is no justification from the minister. The notary is telling us that is not because of the minister's inability to issue land, it's because of their own responsibility as a notary to make sure that when they issue a deed, that everything is lawful. And with the verdict, it is, in principle already deemed to be unlawful. So that's the actual issue with the notaries and the minister. But the minister is, according to the airport verordening, still the one that can give off long lease land. He just has to justify it in a way that for the notaries, they would feel comfortable enough to say, okay, I feel comfortable with the decision maker, the owner of the land, therefore I am going to deed it, which has been done under this minister. I can attest to that. Madam Chair, I wanted to also chime in on the difference between reissuance, renewal, etc., because I think that a lot of people don't really understand that. The DDAM arrest focuses on new issuances of long lease land. That is what it's about. So when it comes to a renewal of an established long lease right, a reissuance, as we call it, that does not fall under the DDAM. Extensions of land that are adjacent to properties that no other person can get also fall under the exception. So we need to basically make it clear to the public what the issue is with DRAM and why they cannot or can receive land.
MP York, you wish to have the opportunity for an interruption. You may go ahead.
Thank you, Madam Chair. You know, in hearing what the good MP just explained, I could only conclude that he is also of the opinion that ministers of now and of the past have too much power. This is something as well that his faction echoed while they were on the other side of the room a couple of years ago. But what I find a bit confusing is in prior meetings, when I say, hey, hillside policy, let's make it an ordinance and make something more, let's take some power away from ministers because they have too much power. The very same MP jumped up and say, hey, it's up to the minister's discretion, so it's okay. Let's leave it that way. So I don't understand. I would like more clarity from
do remember it's
keep it short, yes, I'll
to
finish it,
point,
I'll round it off.
Yes.
I would just like a clear stance of the good MP because he's very knowledgeable on the topic. Do ministers have too much power? Yes. And if so, what are we going to do about it moving forward? Thank you, Madam Chair.
Thank you, MP York, for that interruption. And I now allow MP Peterson to continue.
Thank you, Madam Chair. Indeed, I do agree with the sentiment of MP York, Madam Chair. The minister does have too much power, but when it comes to the discrepancies of policies and landsverordeningen, the law also kind of like regulates what we can put in the landsverordening and what we can't. The hillside policy falls, I think, under policy, which means that the DRAM arrest, the DRAM policy that is going to come, that also is going to be something that the minister can deviate from. Policy is not something that ties the minister. It is an executive law. Therefore, the minister is always going to be able to deviate from policy. But when it comes to the hillside, I think that you know, a clear distinction has to be made as to why we have the hillside policy. Because the ability for the minister to deviate from the hillside policy is actually also part of the hillside policy, because the minister should be able to make exceptions, but exceptions. And that's where I think that the nuance needs to be made. In the past, exceptions have been taken lightly, to my opinion, and I think that the current minister needs to motivate every time that you want to deviate from a policy. And once you motivate, then I think you can actually move forward.
MP Peterson, you may continue with your... MP York, you wish to have another interruption? You may do so.
Thank you, Madam Chair. This is exactly what I meant with my initial interruption. We cannot be selective in when we want to have the minister with less power, take away power from the minister, and then when we're in the seat, we're looking for all the reasons to leave the power with the minister. And it's about across the board something where you can't say yesterday, no tomorrow, and today is different. No, you're either for it or you're against it. And you can't say you're against it when someone else is in the seat and now your minister is in the seat. I understand your position, but you can't say, oh, because my minister there, it's still kind of good. We're confusing the people and we have to keep to one line. Thank you.
Yes, thank you, MP York. You have finalized your interruption. I was just going to remind you, about the brevity of interruptions, an assertion, a question, a statement, and that would be it. So, MP Peterson, you may now continue.
Thank you, Madam Chair. And again, I do thank MP York for his comments because they are valid comments, not in the sense that we are talking about a PFP minister or whatever, but in the sense that you have to ask questions. And as he said, we're here to answer. You can't, in Dutch they say, alles over een kam scheren. You can't put, when it comes to the civil aspect of VROMI and compare it to the government aspect of VROMI. So when it comes to the DDAM...
MP Peterson, I need to interject and ask you to please remember your last word because I'm going to have to adjourn briefly here, members of Parliament, Minister and support staff. We seem to have a little technical issue with the live broadcast, so I'm going to adjourn for 5 minutes until we understand what is happening. Meeting adjourned. Good afternoon. Members of Parliament, ladies and gentlemen, our apologies for the interruption. We are back on track, so to speak, and I immediately ask MP Peterson, who was speaking at the time, I had to adjourn, and I will now give him the floor once again. MP Peterson, you have the floor.
Thank you once again, Madam Chair. I believe when we had our technical difficulty, I was answering the interruption made by my colleague MP York in regards to the sentiment of, in some cases we want the minister to have less power, and in some cases we justify it. I just wanted to make the distinction, Madam Chair, because when we make those type of statements, it makes it seem as if everything falls under one law. And I want to basically remind the public as to how and why the Minister of VROMI is here today. When we speak about long lease, we are touching the Civil Code. In particular, Article 85 of Book 5 of the Civil Code. That is what we call civielrecht. That is a whole different system than bestuursrecht. Bestuursrecht is what we call, for example, the bouw- en woningverordening. And the hillside policy stems from bestuursrecht. It stems from the bouwverordening. So the minister's ability by law when it comes to his civil ability, when it comes to ownership, long lease, etc., and compare that to him as a government body, we need to make that distinction, because I can also read from the exact same hillside policy a piece that basically explains it. It says the guidelines will be used to judge building permits as per the bouw- en woningverordening, 1935, planning permits, the EROP, 1994, and domain land requests, the Erpachtverordening. Then the hillside policy says these guidelines are a policy and not a law. The specific situations will be taken into consideration. And this is what I mean when you cannot legislate character. It was never the intention of the law to basically handcuff the minister and regulate how he has to make his decisions. No, the law expects a certain type of morale and ethics when decisions are being made by a minister. That's why we have policy, because the minister needs to be able to motivate. Because if we were to say, for example, okay, hillside policy, everything above 200 meters needs to go, then we have to break down many houses here in Samate. And that cannot be the case. That's why the minister is there to regulate and facilitate rather than just come and break off everything. Coming back to the policy itself, Madam Chair, I wanted to inquire the minister through you, are there penalties within the policy? Because I think that that also is something that we need to look into. Not only you have to pay your canon, but what happens when you don't? Because if we read the Erpachtverordening, it's a little bit strenger than what we are accustomed to. Because, for example, I saw that MP Lewis asked, how do you request land? Well, a fun fact, according to the Erpachtverordening, if you don't have a 5 guilder stamp on it, your request is invalid, according to the Erpachtverordening. Of course, if we look at how things have been done the last couple of years in VROMI, we accept the public's request because we cannot expect that from the public. It's a little bit unreasonable. But you see, those type of things need to also be in the policy, because the Erpachtverordening at this moment says that that should be how a request is made. So in that regard as well, the Erpachtverordening also says if the canon is not paid, the year after you can take back the land. That's what the law says. We have not done it, but I think that it should be put in the policy, because in some cases I think that it is justifiable for the minister to take back land when the canon has been paid but nothing has been done to the land. And I had a question that somebody posed, and I'll just send it to you, the minister, to you, Madam Chair. Can we not find a way to have our expats abroad who meet the criteria sign in to these type of projects? So not having to move to St. Martin per se. So I think that the person is alluding to the understaffing that we have, and that we can have expertise, and it doesn't need to be situated locally in order for us to actually get some results from it. And I think that for now, that'll be it for me, Madam Chair. I look forward to round 2. Thank you.
Thank you, MP Peterson. And Minister, members of Parliament, ladies and gentlemen, these are the members who wished to speak on this topic, and now I will adjourn for 5 minutes, and I will caucus with the minister on the continuation of this meeting. Meeting adjourned for 5 minutes. Members of Parliament, ladies and gentlemen, Minister and his support staff, good afternoon and welcome back. We had adjourned after, firstly, a presentation on the issue of the issuance of land by the Minister, by Minister Gums, and then followed by questions from members of Parliament, and we adjourned to caucus on the continuation of this meeting. The Minister has requested half an hour in order to come back with the answers, and thus I will now adjourn for that half an hour. So this meeting will be adjourned until 1 p.m. Meeting adjourned until 1 p.m. Members of Parliament, ladies and gentlemen, we had adjourned for approximately 1/2 hour for the Minister of VROMI to return with the answers. On the request of the Minister and his staff, I need to adjourn for another 15 minutes, meaning that we would be starting this meeting at 1:45. So we'll restart at 1:45, next 15 minutes, give the minister the opportunity to finalize the answers that the ministry is working on currently. Meeting adjourned until 1:45. Members of Parliament, ladies and gentlemen, welcome back to this meeting of Parliament, at which time I also welcome back the Minister who took some time out to prepare for the answering of the questions posed by members of Parliament, and thus I immediately give the floor to Minister Patrice Gums. Minister Gums, you have the floor.
Good afternoon again, Madam Chair, members of Parliament, those viewing and listening online, and thank you once again to the Honourable House for your indulgence in the tardiness. I'd like to begin by introducing my delegation, which I promised to do in my next round of speaking. So I'm joined today by my Secretary General, Mr. Kenson Plezimund, my Chef of Cabinet, Mr. Luciano Nichols. I'm also joined then to my far right by the Head of the Policy Department, commonly referred to as VROM, Ms. Raisa Narain. To my far left, the Acting Head of Domain Affairs, Francesca Smith, and then as well, my legal advisor, Mr. Timo Snyders. With that, Madam Chair, I'd like to also thank my team for their very hard work in answering these questions as well as supporting me in this mandate. We begin with the questions of MP Artwell Arian. The question was, individuals with long lease land around the lagoon and the pond area, they have been filling in land. Can the government now charge people for the extra land that has been created? The ministry is aware of these situations. Unfortunately, this is not the right answer. Part of addressing this forms part of E7 backlog and management of domain affairs, one of the 3 other projects within this Lance Paquette country package. Currently, the ministry addresses this during active transfers or requests for extensions. This is then charged with a fine. How many cases do we know of the notary where people cannot execute a transfer because of the DDAM arrest? The new administration has not given off any long lease issuance. Any decrees that have been issued in the past will not be renewed, will not be given off. This will be invalidated by the DDAM. This has been made invalid with the DDAM arrest. Are there any updates regarding Vineyard Heights? As long as there's no new issuance policy, the parcels over the bank cannot be issued. When these parcels will be issued, this will be done in full accordance with the DDAM criteria, meaning that everybody will be able to apply any old decrees that have now been expired will and cannot be renewed. Will the policy also have different specifications of different zones? The classifications of these fall under the country zoning, and of course, the land issuance policy must be in alignment with the zoning regulations. This was mentioned in slide 3 of my presentation. What is the minister's view on the country package specific to VROMI? Does the minister see himself in the country packages, and does he see the value for St. Martin? Any initiative that aims to increase transparency, streamline processes, and improve overall governance has and will continue to have my support. And thus, I see a lot of value towards the country packages. What is the government doing to address notary refusals to sign deeds due to the lack of a transparent policy? There are no issues of notaries refusing to approve new land deeds, as we have not issued any. How will the government ensure the land allocation meets legal requirements to avoid issues with notaries? The allocation of land will need to comply with the regulations as stipulated on the land issuance policy, which of course takes DDAM into account. This must include, as mentioned in slide 4, transparency and strict conditions for exclusivity. Moving on to the questions of MP Christopher Waver. What happens if the tender fails for a 3rd time? If the tender fails for a 3rd time, then we will actively seek and approach.
Minister Gums, if you just give me a moment to allow MP Otley to make an interruption. However, Minister Otley, I need to remind you that you have not signed in. No, you didn't. What happened is that you signed the speakers list. So we'll just give Minister Otley the Minister Otley. We'll give MP Otley the chance, which he did. And in fact, so MP Otley, although you have a signature on the speaker's list, okay, so, but you may make an interruption, and which opportunity I give you now.
Thank you, Madam Chair. Madam Chair, the question was asked about basically the notaries not signing due to a lack of a policy or incomplete policy. The minister replied and said that there's no issue because we have not issued any land. However, there will be an issue. So is the minister saying that his intention is not to issue any land? Because I'm sure that the minister is getting requests, because I am not the minister and I am getting requests. So I need to know, is there an issue? Not that there's not an issue now because we didn't request. Will the notary hinder the processing for new land requests? Thank you, Madam Chair.
Thank you, MP Otley. And Minister, I now invite you to continue, at which time you can, if you can at this moment, address the concern as expressed during interruptions by MP Otley. Minister Gums.
Yep. Thank you, Madam Chair. Let me clarify several things. With the implementation of the verdict of DDAM, I cannot issue a ministerial decree that then has to then be deeded for land issuance without a policy in place. Because currently what happened over several decades is that there was no policy. With DDAM coming on board, it means we have to have a policy. So I'm not even entertaining new requests. If they are entertained, in general, let's put it as a general rule, DDAM does not allow for land to not be issued. It requires a sound justification. When a policy comes in place, a sound justification for why this deviation. Because we don't have a current policy in place, everyone who is requesting land technically doesn't have a fair criteria to which I can issue any ministerial decree to give them the land. So as such, and as a general rule of thumb, no considerations are given to anyone who's requesting land. That's being made very public, and I think very important question, because I think it's something that a lot of people are still very much unclear of, and I began my presentation too by stating we focused a lot on the beginning in DDAM and what it means, simply because there are a lot of requests for land still coming, and if they don't meet certain criteria, which many of them don't, which is basically a fair, open way of requesting land, then they can't be issued.
Minister Gums, I need to ask your indulgence as I allow MP Irian to make an interruption. MP Irian?
Thank you, Madam Chair. Minister, previously, I believe in the budget debate also, you mentioned that there was an issuance regarding Maho, and you said it was a reissuance. But based on the legal framework, even a reissuance that doesn't have any building on it is still an issuance. And that's a discussion that we had with the notary once also. So I want to clarify, that's a question that we had, is when you're giving out land, because that's one of the issues that notaries blocked other parcels already, saying that, hey, this person already had this land, they want to extend the land, and they couldn't either. So how is one allowed to and the other not?
Thank you, MP Irian. Minister, I ask you to continue, and just like before, if you care to immediately respond to the matter raised by MP Irian. Minister Gums?
Yeah, indeed. Thank you, Madam Chair. And I think I clarified this both in Central Committee and in open budget debate. Reissuances are not considered issuances. I think we need to hopefully cement this discussion today so it doesn't come up again. I have reissued several long leases because it's legally allowed. The issue of DDAM is at the inception. It is the personal prerogative of a minister currently, at least in our system, to issue land. The fact that that personal prerogative has no clear, transparent procedure is why, among other reasons, DDAM has come up. So if somebody has a piece of land from 25 years ago, we can't punish them by saying now they can't get it again. They've already made investments on that parcel of land. So reissuances to anybody is allowed. New issuances, for example, Dear Minister Gums, I would like a parcel of land to build a home is not possible. Dear Minister Gums, my parcel of land expires within a year. I want to renew. That is possible. So the difference again, renewal is possible, extension is possible, transfer is possible. New issuances, meaning you don't have a piece of land, asking me for land, not possible. Okay. Continuing on with the questions of MP waiver, is there available CapEx to purchase private land to supplement government-owned land for allocation? There is indeed a CapEx allocation of $10 million for land. This has been proposed several things, including a future cemetery, but this, of course, is still in discussions with the landowners as to what this can be broadened for, including possibly a housing project. Is the temporary policy ready, and how will the government communicate this policy to the public? The temporary policy is not yet ready. And let me just clarify, important to note is that temporary policy is in fact where we internally decide to begin working on something, noting the delays experienced since December of this tender policy. And I'll provide a timeline in my subsequent question as to why that decision was taken when we get to why and how we got to this, where we currently are with the delays. Moving to the questions of MP York, will there be a development plan that integrates green spaces? No. The first question is the MP, my apologies. He stated his desire to see what the directives are. They're lacking in the presentation, mentioned parts of proposed policy as well as government incorporated development plans going forward. Sees a lack of vision, various updates pertaining to status of the policy. Through you, Madam Chair, I wish to clarify that what the MP is asking is outlined in my presentation, specifically on slide 3, wherein which I outline my vision for what needs to be considered in future, including spatial planning concerns, environmental concerns, and cultural heritage, none of which is currently considered. If we look at what has been done in the past, for example, people have been issued land on cliffs, never considering, for example, erosion and environmental concerns, and the fact that you actually can't legally build on a cliff within a certain distance from the shoreline on St. Martin. So this is what I speak about when I said spatial planning concerns, environmental concerns, none of which are there. This forms part of my vision, as well as the cultural heritage aspects as well. The other question from the MP, will there be a development plan that integrates green spaces? Our draft zoning plan and development strategy 2030 is used as a guiding vision for this, and this too is included in slide 3 of the presentation as requested, as mentioned in my first answer to the MP. Will there be a shift in land allocation strategies under the new policy? Our draft, sometimes it's very similar, same answer. Our draft zoning plan and development strategy 2030 is being used as a guiding principle for this. And Madam Chair, through you, this too was included in slide 3 of the presentation. During my presentation, and why I also stated in my presentation, there is indeed an overlap between land issuance policy and zoning. So exactly the question the MP is asking that he's missing from the presentation, land allocation strategy, ties back into what I stated, zoning and land issuance overlap. Will the Minister be coming back to Parliament throughout the year to give updates on the progress, regular updates on this project, as necessary or as requested by Parliament, will, of course, and can be provided. Going to the questions of MP La Cruz. Can the government put a publication on how the population can request long lease in the short term? The request for a short-term publication on how to apply for long lease cannot be done. As stated, no land can be issued at this time, and any procedure on how to apply is not valid, and therefore would be misleading. One will, of course, be published upon the completion of Lands Paquette E7. People who are currently waiting a response from the ministry, they need to reapply when the policy is published. With the implementation of a new policy, the current concept of applying for long lease may in future not be applicable. In future, The idea is that government will manage when a parcel of land is published for acquisition. Government will notify the public of the availability of Maybrief X, and once the defined criteria is achieved, a decision will be rendered. How will individuals who have applied for long lease land over the years and never received a response be addressed? Are requests still active? Through you, Madam Chair, upon implementation of the policy, the government will implement the policy as previously stated. Going back to requests will be in direct conflict with the need to be open and transparent. Moreover, during my term, I have seen requests as far back as 1979 from a typewriter. Managing such a backlog within the confines of current land availability and the anticipated criteria won't be feasible. As such, these requests will not be taken into account anymore. An answer to these requests, one second, and as such, they will no longer be deemed as active. To the questions of MP Ludmila de Weaver, land policy is going to have an all-encompassing effect, covering all other ministries, including those that include monuments. Does this have the potential to be far-reaching? If this is the intention, then what are the current dialogues happening between the ministries? Certainly, this is the intention, to have an all-encompassing strategy. A key task of the project manager will be to facilitate consultations and workshops with key stakeholders, including government, government agencies, NGOs, local communities, business and environmental organizations. Currently, and ad interim, I am in very close consultation with the Minister of TEAT regarding such things as zoning and the development and improvement of Phillipsburg in particular. The question related to questions from MP Lewis. Many persons have applied for years, never received an answer. With the new criteria, can they get an answer? Very similarly, through you, Madam Chair, all old requests, unfortunately, will not and cannot legally be honored, and they would have to be not necessarily re-asked, but based on the new, the idea of what happens in the future. Once government publishes a piece of land that can be acquired, a person would have to apply for that piece of land, and then a criteria would have to be made, would have to match the criteria for the given piece of land as well. And just an example of how we're looking at incorporating zoning and land use. If a parcel, for example, opens up, let's say in the area of South Reward, where there is elements of government land, and someone applies and they want to open a hotel, chances, or a mechanic shop, chances are they won't get that parcel of land because it's not part of the zoning. It would be, for example, for residential. So those are certain criteria of how we sort of link our land issuance policy to the zoning and overall spatial plan for the country, which is not currently done because within the request you just ask for land. No one asks you really what it is you want it for. Moving to the questions of MP Peterson. The status of the cleaning up of the backlog within domain affairs. I'll answer that question later on. In cases of conflict of interest, can a Minister of VROMI handle this being the conflict of interest, I'm assuming, by creating a ministerial decree and arrange that in cases of conflict, another minister signs this decree, who is not even the Plaza Vanga, the replacement minister, for the Minister of VROMI. No, this is not possible. Article 12, sub 2 of the Lands Verordening Integriteit, Bevordering Ministers states that in cases of conflict of interest, where a decision is to be made concerning the minister's spouse or partner, his blood or marital relatives up to and including the third degree, the minister must bring this decision to be made in the Council of Ministers. And the minister cannot form part of the decision-making on this matter. If this is not done, this could be seen as a criminal offense, specifically a misdrijf, and fall under Article 344 of the Wetboek van Strafrecht. summarize, in short, no, you cannot create your own decree to have somebody else approve something for you. Everything in conflict as the Minister of VROMI has to go to the Council of Ministers. Otherwise, it is then an ambtsmisdrijf and is covered by the Wetboek van Strafrecht. And it can be seen as a criminal offense. Status of E7 for clearing up of domain affairs, now in the final stages of selecting a candidate. That is also part of the E7 project, one of the 3 projects within E7. The first one, of course, is, as stated, the cleanup. The second one is a spatial economic strategy. The terms of reference of closing date is also 22nd of February. And we foresee that we will have received enough bids to move forward in the selection phase. So again, E7 is not only about land issuance, it's backlog cleanup, and it's also a special economic strategy for St. Martin. So that includes, for example, considerations of how we again use land, tying into also zoning. This entire approach is very comprehensive and really moves away from the idea of, I want a piece of land, I get a piece of land. To the question of MP Veronica Janssen-Webster, the MP asked, can the minister consider, instead of leasing a single parcel of land to an individual, instead have bundled multiple adjacent plots and enable affordable housing? This is indeed duly noted, and we will look into this opportunity and option. And then finally, I want to outline the timeline of E7, because I think it's very important to also realize that there are a number of statements made here today that give the impression that nothing has happened or needs that they expected more from this presentation. And I think with providing a timeline, we get the reality that within a very short period of time, quite a lot has been done between me taking office in June to actually push this project forward. So I begin. In Q4 of 2022, there was the approval of the roadmap for E7. Between Q1 and Q2 of 2023, the making of a plan of approach and defining the project took place. The plan of approach was then submitted to the various administrations levels, however, never signed and approved. It was then resubmitted to the new administration. So, beginning of 2023, we don't actually have a signed plan of approach. The plan of approach was signed by myself at the very beginning of my term in June 2024. So, between June, beginning of 2023 to now, reminding everyone that the decision to abandon an actual interim policy on land issuance was taken in 2023, and the decision was taken actually to only focus on E7. So between 2022 and 2024, no initiative was taken to develop a land policy. The decision was taken to rely solely on whatever the consultant of E7 decided was going to be the policy, to which I only approved in June when I came in. In October 2024, there was an approval of the terms of reference for this consultant. And finally, in May 2024, we published the terms of reference, to which we are now experiencing a third delay, roughly 2 months after its publication. So, in the desire to have more of a presentation done, I query what was done between 2022 and 2024. The plan of action for a plan, as decided by a government to abandon any interim plan and rely on a consultant, was taken in 2022-2023. This plan of approach only approved in June, and we actually were only able to approve the terms of reference of this consultant in October. So that's why I stated, given the delay from the time of this meeting being called in 2022 to now, almost 2.5 years later, we have done internally a decision to start working to guide whoever the consultant may be with our own internal homework. So, looking at, for example, as I stated in my presentation, the Crown Land policies of BVI, the best practices in St. Kitts and St. Lucia. So I indeed, myself, at this 2.5-year gap would have expected a bit more to be there, but the reality is that the decision was taken to abandon this and leave it until whoever came in to make that decision. So, with that, that comes to the end of my questions and my responses, and I hope to clarify a lot of the things and a lot of the sort of sentiments of more needing to be done. And I also, thank my team as well for basically keeping this going in the background as much as possible as we go forward. So, through you, Madam Chair, it's the end. I look forward to the second round of questions.
Thank you, Minister Gums, for the answers provided. And we now, of course, have the opportunity for clarifications. Is there any member who requires of the minister that clarification is given on anything stated or answered? We do have MP La Cruz who wish to make use of the possibility to ask for a clarification. MP La Cruz.
A blessed afternoon, Madam Chair Lady, Rifir, Minister and his support staff, and my fellow colleagues. Madam Chair Lady, if I understood the answer to my question from the Minister, which is that everyone would have to reapply who already have requests in for a piece of land, Madam Chair Lady, I think that is crazy, is a good word to use in this situation, because there are people that have been waiting for years and years and years, and it's very much unfair, because when we have, for example, 10 lots available, it will then most probably be who first come, first serve on those. And if that is not the case, then I would really like to know what the case would be. But again, there's no policy. But not being able to go back and look at those people that have been waiting for 10, 15, 20 years, I think that is very unfair. So I don't know if when putting a policy together, that is something that could be taken into account, especially because these persons have never received a letter back from government stating, hey, this request is not granted or cannot be granted because of A, B, C, and D at this time. Thank you, Madam Chair Lady.
Thank you, MP La Cruz. Any other clarifications necessary? I see MP Lewis. MP Lewis, you have the floor.
Just to chime off what my fellow MP La Cruz just said, with regards, as government has its obligation of continuity, I would like to know, or if it can be clarified, do we have a log book or a logging system of all the different applications that was made? I know everything goes through the DIV system, but is there a department in the Ministry of VROMI that has a log of all application for long lease requests? Thank you, Madam Chair.
Thank you, MP Lewis. I see MP Otley has the need for a clarification. MP Otley.
Thank you, Madam Chair. Madam Chair, through you to the Honorable Minister of VROMI, I hear my colleagues speak, and I hope to God that they misunderstood or misinterpreted what you said, because indeed that would be a catastrophe. There are many, many, many persons, as you know, Madam Chair, through you, that are here, that are requesting land, that are struggling. And we have not only a land crisis, a housing crisis. So to hear that those who have taken their time, followed the process, put in for land, will no longer be considered and will have to be start over, will be a catastrophe in this country. So I hope and pray that my colleagues heard wrong or misinterpreted the information. So I look forward to clarity on that, Madam Chair.
Thank you, MP Otley. Any other clarifications for the minister? No, that does not appear to be the case. Minister, can you go into the clarifications at this time? Then I invite you to do so.
Thank you. Thank you, Madam Chair. To the clarification requests of both MP Otley and La Cruz, let me just explain exactly how come they become sort of no longer active. The current criteria is you send out to the minister and you either get a response, yes, no response at all, from 1979 to now is 46 years, or you get a response that's positive. The issue is in the idea of what governments are supposed to do when it comes to the DDAM criteria is you're supposed to publish every piece of land that becomes available. So if I have to inventorize 46 years of requests, some of which we don't actually have anymore in the system for different reasons, either hurricanes or they're lost because it's really became digital relatively recently. For every person whose request I want to entertain, I have to then publish, I have to find a piece of land for that person, and I have to then put it out and possibly get 10 and 15 more requests for that same exact parcel. Times 46 years, all those requests per year, and the land availability, you cannot at all honor what is currently outstanding. Secondly, in the new system, based on what DDAM has, that also aims to make it fair and equal, government has to, at the onset, put a piece of land out. What's happened in the past is, and I'm sure everyone knows this, when you ask government oftentimes currently, and even in the past, what land is available? Oh, there's no more government land available. But for the last amount of years, there has been a lot of issuances of land. If I have to issue land to persons now because they have a request in before, that automatically makes it unfair to those who may request after this policy. The reality is, as well, is that we have no policy currently. So the whole idea of DDAM is it also helps government manage land, which is also part of the whole idea of land and spatial planning management. So government will control what parcels of land are available when, and they go out in public. So everyone at 1 p.m. today will know May brief X is available. It won't be, oh, there's no land available, and then because you have a request in from 15 years ago, you get the land. That's not fair. So while it is indeed a catastrophe, as indeed it might be considered a catastrophe because of the amount of requests given in, unfortunately, the fact that we didn't have a policy in the beginning is actually the catastrophe. If you will recall, and I stated it in budget debate, there are persons who have requested land from 1979 have not gotten a request. There are examples of ministers of VROMI who have come in and within their term have issued land to their very close time members, their political friends. That's the catastrophe. And this is exactly why we have a housing policy that needs to come to place. Because the reality is, the people who need the land the most oftentimes don't get the land currently. Who gets the land is the friends and the family of the minister. That's the catastrophe. So the catastrophe will be addressed by the DDAM. And persons can reapply again, and they'll have a fair chance to get the land. Because currently what's happening is, who is getting the land is not oftentimes getting it fairly. And I see interruption.
Minister?
Yeah.
The Minister, one moment as I allow MP York to take the floor for interruptions. MP York.
Thank you, Madam Chair. Madam Chair, I agree with the Minister on the fact that most of the time the people who needs to get the land don't get the land. I understood in the explanation from the Minister that they did a lengthy research. I would like to know from the Minister, dated how far back do these discrepancies go with ministers just giving away land to family members, etc., and to political affiliations? How far back does this go?
Thank you, MP York. Minister Gums, you may continue.
Indeed, this goes back decades. That's exactly what I stated too. It's not an isolated issue to the last 4 years or last 8 years. It's pretty much from the very beginning where whoever has, as you become minister, you get everyone's sort of backlog. 1980-something, 1979. I haven't gone as far as 1979, but I'm sure they're out there. There are people who have been requesting land and have not gotten the land. And the reality is, the prime land oftentimes goes to those closest to the government. And that is a catastrophe, not the fact that somebody who really needs the land doesn't get it. And with the policy, they will get the land once the criteria is met.
Minister, if you allow me, I would give the floor for interruption to MP Otley. MP Otley.
Thank you, Madam Chair. Honorable Minister, thank you for your elaborate explanation. Just from my knowledge and the public knowledge, the previous minister, there was land, I guess a whole issue that he faced where persons that had applied for land were not, and I guess were dismissed or put aside, and new persons applied due to him putting out basically an article asking for a reminder to re-register or whatever it may be. Now, this minister received major criticism for the fact that basically what it sounds like, what you are saying now, is that a process has to start over and new persons have to reapply. The then minister received major criticism for the fact that he did not continue with the persons that were there. But it sounds like the same thing, so if there's a difference, I would like to know, honestly, Minister. Through you, Madam Chair.
Thank you, MP Otley. Minister, you may proceed and respond to the members if you can.
Yeah, so indeed, what it boils down to is, with this particular case, and I think if it's regarding Vineyard Heights, yes, indeed. So what's important to realize is, and this is a very important thing that I've experienced now since becoming minister, people are under the impression that if they have a ministerial decree, they have a piece of land. Until a piece of land is deeded, it's not your land. And what I've experienced in the last, even up until last week, someone's dad received a piece of land when he was a very young child, and he's now an older man and wants to deed, he thinks he has the land, but he never actually owned this land. So the issue now in particular with this is that some people have deeds, some people don't have deeds, and you have a situation where then a new administration comes in and then issues new MBAs or deeds again. So again, it boils down to the fact of not necessarily this case, but there are cases where oftentimes they can go right, and in some cases, and more often, it does go wrong, because again, there's no clear criteria. Every administration comes in, has a new take on how they should issue land. There's even ideas of putting, maybe even in a lotto and raffling them off. That's also something that is part of what you can do. But every administration has a different take on what to do, and the issue is that every time it changes, the rationale becomes different. So with this whole policy, then you have very clear, very open, relatively unchangeable policy that basically satisfies this verdict that's been rendered by the court. Then there was one more clarification, I believe, from, yes, MP Lewis, regarding how documentation is booked in. Indeed, documentation goes via DIV. And then this basically goes to the Department of Domain Affairs. Domain Affairs then goes through the documentation as it comes in and then issues the land request. Important to realize, and I think MP Peterson alluded to it too, a lot of the work of Domain Affairs and how I think VROMI and maybe government as a whole is structured, a lot of the ways that VROMI is operated or structured tends to rely or base on the idea of a very small St. Martin. we actually getting to the point we have a number of the renewals coming up for a number of the first initial long lease issued many years ago. That backlog means that you have to manually go in and create the advices and the MBAs for me to re-sign to make them better. So indeed, there is a backlog that currently exists even to renew what is already issued. So I think to the MP's question was, how do we address this and where is the backlog coming from? The fact that we have a very manual system that relies on a very small SIMARTIN and a small amount of land issuances. There's hundreds, if not maybe possibly thousands of issued pieces of parcels of land, to which we manually, with a staff of about 4 people, have to manage all of SIMARTIN domain affairs.
Minister?
Yeah.
With that explanation, I would give the floor to MP La Cruz for interruption.
Thank you,
MP La
Madam Chair
Cruz.
Lady. So what I understood the minister said that a piece of land has to be available first, and according to the court case, available and then published for individuals to then request that piece of land. But as far as I know, and what I've always heard was if you go to cadastre, you ask, hey, is there any land available? You get a document that says, hey, this piece of land is available, and you go in and you put in for it. So those requests are in on pieces of land that are available, and that's what I don't understand.
MP La Cruz?
Thank you, Madam Chair Lady.
Thank you, MP La Cruz. Now, I was just going to remind you of the interruption possibility. And so I now give the floor to the Minister. Minister?
Yeah. Thank you, Madam Chair. And again, a very good point that's raised here. There are instances as well where persons have come to the government and have also asked, for example, is there land available? And they're told there's no land. There's also instances that I've been told, I mean, I can't verify them, they're pretty much word of mouth, where people request government land and then from the cadastre, and they're issued the request or they're not. That's a different situation altogether. Or they get the cadastral extract of a piece of government land, they submit it, they don't get a reply from government. So again, this is why the need to have a very managed, transparent situation where it says, this is available. There's no gray area of where this land is, it's available or not. Government tells you this is available, you want it, apply based on the criteria. Because what happens now, and I can tell you time and time again, I've seen it myself, there's no government land available. And then all of a sudden we see that we see deeds going out of government land issued. So I guess, again, the whole point of this is to avoid having to rely on people who you may know or someone who doesn't like you to tell you, yeah, there's government land or not, because that's currently what's happening. What's currently happening is you have to know that there is government land or where to go for government land to basically even begin the process of asking for government land. And this policy is to make it very transparent. This is available, apply or don't apply. Yeah, that's it, my clarifications. Sorry, that's all the clarifications.
Thank you, Minister. Members of Parliament, now we go over to the second round on this topic, and we would go according to the speakers list. And I start with MP De Wever. MP De Wever?
Thank you, Madam Chair. I have no further questions. Thank you.
Noted, and thank you, MP De Wever. MP De Marla Bega?
Good afternoon this time. It's not morning, so good afternoon. You know, I want to thank the good minister again for coming to Parliament and explaining this. And as some previous MPs stated, they don't see the value in being here. I wouldn't say being here, but the presentation. No matter what it is, it's always good, even if you're hearing the same thing over and over. Right? Because to me, that's transparency. Everybody asks for transparency, but the minister is here with his staff giving what is going on, giving what needs to take place. And no matter how you look at it, government land in St. Martin has been an issue for a very long time. There's going to be no winners here. The individual that applied decades ago, years ago, they have been land given out that have overlooked them, as the minister stated. And that goes back to a lot of ministers. So we're not just looking at one person or any administration per se. The people that now going to apply for government land, should they now be told you can't receive government land because people applied? So there's no winners, to be honest. It's going to be a very tough decision being made on the behalf of VROMI, but the conversation has started, and fairness, however that is brought forward, is always welcomed. So with that being said, I thank the minister and his staff for coming and giving the presentation and explaining what they have explained. Thank you.
Thank you, MP Labega. I continue with the speakers list, and I invite MP Janssen-Webster to take the floor.
Good afternoon. Thank you, Madam Chair. To the Minister, I would like to thank the Minister for being here and for his presentation, and I look forward to receiving the final document and also to the implementation of the document. Thank you. No further questions.
Thank you, MP Janssen-Webster. The next MP up to speak is MP Lewis. MP Lewis, you have the floor.
Minister, through you, Madam Chair, I find this is a very important topic, not just to me, but of course to the vast majority in our beautiful country. And as we thrive to become a better and articulate country, it is important that we start modernizing certain things. So I was just mentioning the point when it comes to the backlog. And if the Ministry of VROMI is planning to digitalize incoming documentation, it's sad to know that we only have 4 employees. And how soon will the Minister, through you, Madam Chair, put out the application so that we can have someone put in place to start drafting this policy? Because at the end of the day, the people is suffering, okay? So I think we need to start accelerating the process of hiring an individual that can start drafting this policy. So how soon is the Minister planning to put it out there that we can start this recruitment drive so that this policy can commence? Why is the Ministry allowing individuals to purchase and sell property only for them to be informed when they apply for a building permit 3 years later that the land is designated for agricultural use despite being intended for construction? I have received numerous complaints from frustrated individuals who purchase land with the expectation of building their homes, only to later discover that a lot is restricted to agricultural use. What step is the Ministry taking to prevent such misunderstandings? In saying so, in this policy, would we have a zoning outlining what is for agriculture, what is for residential, what is for commercial? Does the Ministry have a system in place that allows prospective buyers to verify whether a parcel of land is designated, as I said, for residential, agricultural, or any use before purchasing? If not, are there plans to implement such a system? How long does the government have to process a building permit request? I would like to know the exact article of the law that governs this matter. There has been much talk about the boardwalk and expanded beach to protect the coastlines. Is that still in VROMI's bucket list as an initiative to be handled in the near future? What measures are in place to ensure that the distribution of land is conducted in a transparent and fair manner, preventing favoritism or corruption? I think you already mentioned that, but that was one of my questions. How does the Ministry ensure that land allocation policies promote social equality and prevent marginalized communities from being disadvantaged? With that, I conclude my questioning. Thank you, Madam Chair.
Thank you, MP Lewis. The next MP up to speak is MP La Cruz.
Thank you, Madam Chair Lady. Madam Chair Lady, it is not to be in any way whatsoever difficult, but I'm even more worried now. And I want to explain so the minister could understand exactly what I mean. We have two different situations. We have a situation A, where now we're going to use some CapEx money and buy some land from a private family, and it's going to become government land, and now we can give this land out. That's situation A. No one has ever requested that piece of land because that piece of land did not, never belong to government. The situation B is there is a property in cul-de-sac area. This property belongs to government. I went to Cadastre. I asked at Cadastre, is there any government land available? They took in cul-de-sac area, and I was told, yes, this is available. It got mapped out. I got that document. I put in that request by government for that specific piece of land. What I am understanding from the minister is that he is saying that even that will again go out, that everyone could bid on that piece of land, while I have been waiting 5, 10 years, 15 years for a reply from government for that piece of land. That I don't understand. That I don't understand at all, at all, at all. I think when putting that policy together, there should be a difference between what is already there and who has requested it. And I understand that you might not be able to find all those requests. Trust me, I've been down in VROMI and I've seen it myself. So, like my colleagues mentioned, digitalizing should be a priority, but this is a problem. This is a big problem. This is something to you, Madam Chair Lady, to the minister, that is going to even be a bigger problem than any other problem that has existed. Because eventually people are going to say favoritism. Because what will stop now, for example, it comes out, my brother knows that it comes out, he puts in for a piece of land, and then it is said that he received that piece of land because he is my brother, while others were already there waiting. So, Madam Chair Lady, to you, to the minister, once that policy is in place, I'd like you to read it over 100 million times, because it could be damning, 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 damning to everything and everyone. Thank you, Madam Chair Lady.
Thank you, MP La Cruz. We continue with a list of speakers, and I invite MP York to take the floor.
Thank you, Madam Chair. Through you, Madam Chair, I just have a few questions for the Minister. Madam Chair, I heard a lot of, and one of the previous speakers spoke on it again, transparency. And what I'm about to say is no pointing the fingers towards the Minister about transparency, but about the topic in general, about the word in general. We should not only be transparent within government or government towards Parliament, but also the requesters as well, right? And in one of the Minister's explanation, he alluded to the fact of when it comes to land issuance, it's either you don't hear anything or you get positive news. Something in between there is missing, right? So as well, you have people weekly either going to the government building or approaching the minister or approaching a member of Parliament out of frustration because they don't know the status of their request. May it be a week old, a month old, a year old, a decade old. And it shouldn't be that only when you're awarded you hear from government, and otherwise, zukit marat. So I think in the vision of modernizing, as what the previous MP Lewis said, there should be a system worked on or made where this transparency can also be communicated to the public, to where even though I'm number 1,000 on the list, I know that I'm a number 1,000 on the list. And if I'm number 999, I know that I'm 999. So that would also take away a lot of frustration that's out there in the public. As well, we're talking about land issuance or reissuance, but what about enforcement of the land that has been issued already, right? Because right now what you have a lot is encroachment, where you have landowners moving over, I wasn't moving over, but also making use of land that does not belong to them. And we're quick to say it falls under the civil code, but what does it fall under when someone is taking over land that's public, right? So I'm a landowner, my bound goes up to here, but I go extra 5 meters over, extra 10 meters over, which is public property. What happens then? Is the public supposed to take this person to court through the civil code? Or is it expected of the government to enforce the law and take back their domain, right? So I would like to know from the minister, what is the procedures where that is concerned? As well, if you're looking at education moving forward, the best education, you should start with your own country, right? So what and when was the map of St. Martin last updated, also for public and displayed to the public for public consumption? Because in the school system, even dating back to when I was in school, I can't remember an updated map of St. Martin being shared out to where we know exactly the updated districts, the updated street names. And I was talking about street names, when will that be updated and what's the status on that? Check to see if that's all. Right, so going back on the street names, once that is updated, or basically once the status of that is known, basically the street names on Google would also make sense as well, because if you're doing Google Maps, you will be led to somewhere, through you, Madam Chair, that you didn't ask for. You can't find certain areas in on the island. And if we're talking about land issuance, just now we'll be issuing land that cannot be found on Google. So what is the status on that, and what are the plans for the minister as it pertains to that, through you, Madam Chair? And that would be all for my questions. Thank you.
Thank you. Thank you, MP York. I continue now with MP Weaver. MP Weaver, you have the floor.
Thank you, Madam Chair. I would first like to thank the Minister, support staff for answering the questions and also for the presentation given. I think maybe in the whole interruption phase, during the answering of my question, the first question that was posed regarding what happens after the deadline, the third deadline, I think that was cut short and maybe not given the full answer. And then if the Minister could maybe repeat that answer to that question, to have that known, and then also to ask a follow-up concerning that. What is done or what is put in place that we can appeal to our locals, whether here or abroad, that the expertise there, that we can ensure that they have a preference when it comes to also the tour, that they're able to have a fair chance at getting this or winning the tour as requested. Thank you. That'll be all.
Thank you, MP Weaver. I continue with MP Irion. MP Irion, you have the floor.
Good afternoon, Madam Chair, colleagues, everyone viewing. Minister, thank you for the answers given thus far. Minister, so I'm not a legal expert like some of us inside of here, but I do have some resources, and we did have to deal with the whole DDAM case while in government. And during the break, I just contacted a person, a legal mind from the Netherlands that also has experience in this, and just want to summarize a little bit, or maybe go back a little bit on what the DDAM case was about. The DDAM case, in summary, was about transparency and equal opportunity. I think you mentioned that. And the person says it's about fair and open selection, which you also kind of indicated. And something that I learned during my term was they wanted it to be about fair competition and about public announcement so that everyone had a fair opportunity to say, hey, this land is available. I should be able to have access to this land too, no matter what list there was before. And that wasn't done ever in the past. And that there would be legal consequences for failure to comply. I also specifically asked, or we had a discussion in here with a couple of MPs, I would say, because I remember while being there, and we had a couple of cases dealing with the notary, and I went back to this lawyer just to get confirmation from the Netherlands on this topic. I specifically asked the notary and the lawyer at that time, and our legal advisors at that time, if there was any kind of development on the government land, right? The lease is over and becomes available. Does that mean that even that land then has to go back into this fair policy? And they said, yes. Once you do not have a land policy that indicates, hey, if you have any type of infrastructure built on the land, that then this person gets first preference, or this person then gets the first choice to execute, or it just automatically goes over to this person, then everything goes back into the pool, basically. Everything becomes fair game. So then what then government will have to decide is then that the structures on top there, that, well, the infrastructure, the person then could decide, hey, yes, I want this land, and I'm willing to absorb this cost to whoever the owner was before. But it states, because I also asked, so I said, okay, confirm for me. It said, no, lease land with property on it should not be given out without a clear land policy that explicitly allows it. That's the same thing that was told to us then, and even with legal. So I want to ask a question now, because what you stated was basically your opinion and my opinion. So I'm going to ask, do you, as a minister, the ministry, did you get legal advice on, at least within government, on the fact of property already being on the long lease land and being allowed to give given out without a land policy indicating so? And even if you decide to do that, it had to be publicly announced. And that goes back now to the whole Maho situation. I want to be very clear on this. Was Maho reissuance or an extension? Was it reissuance or an extension? And yes, there was a whole investigation going on with cadastre and so forth. Can we get an update on the whole cadastre situation, or any updates that the government can give us on that situation? Yeah, I'll leave it there and let's look forward to the answers, and then I guess deal with it in clarifications.
Thank you, MP Irian. The next speaker up is MP Peterson. MP Peterson, you have the floor.
Thank you, Madam Chair. Madam Chair, I'll take this opportunity to elucidate on a couple of topics that were mentioned, just for some clarity. To start off, MP Irian mentioned if a parcel of land is built on, then that also falls in the pool. I believe that the lawyer he's speaking to has things a little confused, because when it comes to the civil aspect of things, natrekking is a thing. So if you build your house on top of government long lease land, government, when your long lease expires after 60 years or whatever, government indeed has the moment to reissue or not. Now, that moment is a momentopname. It's not automatic that you get a reissuance. But if you look at the legality of things, first of all, if government wants to remove you from that property that you have in long lease and that you built your house on, government has to pay you out fully for the value of whatever you have there. That's number one. So as the facilitator of long lease land, government in no way is deemed to be the one to take back your long lease after you have already built on it. That is not the intention of giving off long lease, if you read the law. So to put the Maho case, so to say, within the same boat, Maho was originally 3 parcels. So if we're going to be very technical, all 3 of those parcels have something on it, whether it's an infrastructural or a building permit. There is a permit on it, volgens de bouwverordening. So built on, that criteria has been met. Now, when it comes to a reissuance of a zakelijk recht, which is an erfpacht, that is a civil code. The didam arrest, that goes over the decision-making. the decision to issue land is deemed unlawful because there is nothing regulating that. That is what this is about. So I heard today we spoke about notaries hindering the process. It doesn't work like that. The notaries have what we call the wet of the notaris ambt. They have what we call a notariële aansprakelijkheid. And I think in St. Martin, I think they have to be insured for about $1 million minimum. But basically, the notary bears the risk when they pass a deed. So that is the issue. The issue is that the decision by a Minister of VROMI to issue land is automatically deemed unlawful volgens de Didam-arrest if there is no policy. The Didam-arrest also explains that from 2021 and up, you have to do it different. So we need to be very careful when we inform the public of these things because people out there, they want land. They think that government land is something easy to get. They think that it's a legacy. I can be very clear and honest because MP Lacruz spoke about it, that normally you go to Cadastre and you ask if there is available government land and they give you a list. That is also not true. What Cadastre has is a system where they have every meetbrief and they can show you within that system of all of these meetbrieven which have a notarial deed on it. That is simply objective information that anybody can go to Cadastre to get, not only MPs or the Ministry of VROMI. Anybody can go to Cadastre and get that information because that is what a deed is. That is what Cadastre does. They're the registry for onroerende zaken. So if you go to the Cadastre and you find a piece of land, so to say, that is available, meaning it doesn't have a deed or it wasn't deeded, that piece of land still might have a property on it. It still might have been built on in the past. And that means that that piece of property that you would then go and rightfully request, because there's nothing on it, we would send inspection in VROMI. They would go, they'd be like, oh, wait a minute, this is a piece of land with no deed on it, but there is already a structure on it, which then translates into the civil law. There's something on it, door natrekking, now you have to pay out whoever is there, whether or not they were there with permission or not. They invested their money, that is their property, on top of the property of the government. So it gets a little tricky when it comes to the legalities of things, but I just wanted to make it clear that if we are going to cut out everybody from the past, I personally believe that legally that can't happen. If you look at the principles of good governance, everybody deserves an answer, and I think that the minister also alluded to the fact that everybody is going to get an answer, but the answer is not to be a formality. If somebody requested in 1979 land, of course you're going to check if that person is alive, but we can't say that somebody that requested land in the year 2020 also falls under the same boat, although it's also in the past. So I think a case-by-case basis is how you have to look at it, but requesting land from back then, if said person is alive, then I am of the serious opinion that if said person still wants a piece of land, that they should get an answer before anybody else that has requested after them or even now, after the Didam-arrest. That's fair. You know, so I think that when it comes to that aspect of it, maybe some discussions need to be had. But other than that, I think for me, the presentation was pretty clear. Of course, I can understand the confusion for some MPs, and it's justified because I also was a little bit alarmed when I heard, okay, everybody from the past is now going to be cut out. That's not actually what I have been speaking about this last couple of years. I actually want to make it fair to everybody. Whether or not they get a piece of land, they still need to get an answer. When we look at what happened, for example, by over the bank, I believe it was MP York who alluded to it, or MP Irian, when you asked about the land being placed publicly, something like that. You said, I think I'm looking at MP Irian. I think that he referred to the land being having to be announced before. Yeah. So back in 2016, when I started working in domain under the then minister, one of my first cases was the over the bank case. And the then minister requested the Department of Domain Affairs, and the acting head of domain was also there as well back then, so she can attest to it. Over the bank property came about. It was about 80,000 square meters, and the minister wanted a plan from the ministry to issue the property. That was my first case, so like MP Irian quite rightfully said, my first instinct was, okay, first of all, we announce it, that there is land in over the bank to be given off in long lease. Our second step was to gather all of the requests that people, and it doesn't matter if they requested in the 70s, like you said, people requested specifically for that area. We took all of those requests, it was about 200 and something, almost 300, and we categorized them, the requests of the people who requested land in that area. Once we did that, we categorized them in young professionals, established career professionals, etc., students or whatever. After that, we decided to take that and say, okay, you have, I think it was about 50 parcels, about 300 requests. Our proposal to the minister was, let's bring this information, these 300 requests, and the availability to the notary. Tell the notary that maybe 5 of these parcels can be given off at the minister's discretion for exceptional purposes, but the rest need to be done via onafhankelijke loting, a lottery system where objectively they get picked by the notary who gets the land and who not. And this is actually an example of where I can attest to the fact that government, or actually the civil service, tried to do the right thing. And once we brought this proposal to the minister, within 2 minutes of hearing it, he shut it down. He went into his desk, he brought out the USB, and on that USB he had 50 decrees already made up and 50 advices already made up just for the Department of Domain Affairs to just sign and go ahead with. So to answer one of the MPs that asked, since when has this corruption been going on? It's been going on forever. So we need to actually start from scratch now to fix it. And I just wanted to finish up with that little anecdote. Thank you, Madam Chair.
Thank you, MP Peterson. Minister, we have come to the end of the questions in the second round, and I will now adjourn for 5 minutes to again hear from the minister how he would like to proceed. Yes, so I'll adjourn for 5 minutes. Meeting adjourned.
Oh, sorry.
Members of Parliament, ladies and gentlemen, Minister and support staff, good afternoon. Welcome back after that brief adjournment. Members of Parliament, after a brief caucus with the Minister is able to respond to the questions of members of Parliament, but would need approximately 1 hour. So we will adjourn this meeting until 4 p.m., at what time the Minister will return to respond. So with this, members, Minister, ladies and gentlemen, this meeting is adjourned until 4 p.m. Meeting adjourned. Members of Parliament, ladies and gentlemen, good afternoon and welcome back. We continue this meeting with Minister Patrice Gums responding to the second round of questions by members of Parliament. I immediately invite the Minister to take the floor as he brings the answers to the members of Parliament. Minister Gums.
Thank you, Madam Chair. We'll dive right in to the question posed by MP Lewis. Why is the Ministry allowing individuals to purchase and sell property only for them to be informed when they apply for a building permit 3 years later at the land designated for agricultural use, despite being intended for construction? The case he's received. Okay, so begin again. Why is the Ministry, the question of MP Lewis, why is the Ministry allowing individuals to purchase and sell property only for them to be informed when they apply for a building permit 3 years later at the land designated for agricultural purpose despite being intended for construction? The MP indicated he's received several or numerous complaints from frustrated individuals who purchase land with the expectation of building their homes to discover after that it's restricted. What steps is being taken to prevent such misunderstandings? In general, land purpose conditions are included in deeds and are in compliance with the land use regulations in the zoning plans. A person must build according to their deed. A person must, in the past, this wasn't always followed. Since taking office, I have worked towards respecting this and have sent back several requests if the purpose doesn't match the proposed development. If a person wants to build something on a parcel that doesn't comply with the land purpose as in the deed, a request needs to be put in to change this purpose. So again, land purposes and their conditions are in the deed. It is actually on the responsibility of the person purchasing the land to ask these questions about what exactly they're buying. And if a change, of course, is needed, that then has to be requested by the Ministry. Is there a system in place that allows prospective buyers to verify whether a parcel of land is for residential or agricultural use before purchasing? If not, are there plans to implement such a system? This information can, of course, be requested from the Permits Department, which is VROMI Permits Department at stmartingov.org. Of course, you have to be in possession of a deed or have the information. So, of course, there's not really a general way of looking at this. So each person is encouraged to contact the Permits Department to find that out with the provided email. How long does the government have to process a building permit request? I would like to know the exact article of the law that governs this matter. Very interesting question. I can expect probably a lot more ombudsman reports after this, but there's a National Ordinance on Building and Public Housing, Article 21, which states, subject to the application of the previous article, a decision shall be taken as soon as possible, but no later than 1 month after the application has been submitted. The decision will be communicated to the applicant in writing without delay, returning one of the submitted drawings. Important to realize once again that the building code that we currently use is quite old and does not match, for example, the amount of requests that we have. Neither does the staffing match the amount of requests that we have. So the idea of receiving a response to a building within 1 month doesn't take into consideration, for example, things like swimming pools, multiple-story buildings, multiple-story homes. This is a very old building code which envisions a very different St. Martin. So again, these things have to be adjusted to match the current reality of our country. MP Lewis continued to have questions regarding talk about the boardwalk, an extension of the boardwalk to protect the coastline. Is it still in VROMI's bucket list in the near future? There are, of course, ongoing discussions regarding not only the extending of the boardwalk, but also on enhancing the capacity of the boardwalk to act as a flood and erosion mitigation tool. These conversations are being predominantly held by the Department of Infrastructure. and of course the Ministry of TIAT as it relates to development of the further development of Phillipsburg. What measures are in place to ensure that the distribution of land is conducted in a transparent and fair manner, preventing favoritism or corruption? How does the ministry ensure that land allocation policies promote social equality and prevent marginalized communities from being disadvantaged? As mentioned in my presentation, what the principles of land policy will be, specifically the land must be issued in a fair and transparent manner, taking into consideration social equality, while with the policy, everyone will have the equal opportunity to apply for government land. The question of MP La Cruz: if someone has been waiting for years for a response on a land request, will their request still be honored, or will they have to compete again? Yes, they will have to compete, in that term of word, again. The second ruling of DDAM confirmed, this is one of 2024, November, that DDAM rules have no temporal limitation and apply to government actions prior to the initial, even prior to the initial DDAM ruling of 2021. MP La Cruz's second question: should there be a distinction in policy between newly acquired government land and land that was already owned by the government? Based on the principle of equality, there can be no distinction. What measures are in place to ensure that those who have been waiting for land allocation for many years are not unfairly displaced by new applicants? As stated, those persons who applied in the past will have to apply for long lease land upon publication by the government. They will, of course, be treated fairly and as a new applicant. The question of MP York: we need to be more transparent to applicants. Either we don't hear anything or we hear positive news. What happens in between? People need to be informed about the status of their requests. How can we be more transparent to the public? MP York, through you, Madam Chair, I can fully agree with you on this and forms part of our plans for enhancing good governance and rebuilding trust. The current manual system and limited capacity needs to be addressed. And of course, forms part of E7. People are occupying public land, they go over their boundaries. What is government doing about this? Similarly to issues regarding the lagoon, once government finds out about encroachment, action is taken to correct this immediately. When was the map of St. Martin last updated? VROMI has quite accurate LiDAR aerial imagery of St. Martin from 2021 and is looking into which basic layers, this is of course street boundaries, parks, etc., need to be updated. Will the updated map be updated? Will the updated map be shared with or given to Google as well? Google uses satellite imagery to generate data. We haven't uploaded data to Google Maps before. MP waiver: how can we give preference to locals to apply for the tour? Important to note that the tour is already out, so this itself would be, for this current situation, wouldn't be a change at this current time because it ends on 22nd. But of course, this can be looked into for future tours, what options there are to include this in every single tour going forward as a consideration where possible. And the tour states that this tour does state that we do prefer people who live on St. Martin currently. Also, going back, and apologies for this, Madam Chair, to the question of MP Lewis, I realized in answering this question that we actually missed his question where he asked how soon can this application be published. It's been published since November. Back at the second question of MP waiver, what happens after February 22nd? Indeed, we missed it, so my apologies for that. If this is the case, the project team and myself will come together and discuss the possible next steps. Furthermore, I can share with you, we are also, as an option, looking into extending possibly a fourth time, that I think for another 3 weeks. That's something we have to discuss as well, given that we are now at the second extension. And meanwhile, I can imagine that we will proceed working further on the draft policy in-house that will continue to guide the work of whoever we do find eventually, using local knowledge within the ministry as well as the ZNV towards possibly headhunting someone with more of a focused selection for the policy writer for this project. And finally, we come to the questions of MP Arian. The ministry seeks legal advice on whether land with existing structures can be allocated under current regulations without a land policy in place. Let me come back to that question. The second question, if government land with built infrastructure is to be issued, does it have to be publicly announced for fair competition? Madam Chair said before, the DDAM arrest does not affect a reissuance. This is also confirmed by our legal, who advised the ministry to proceed with the renewals. And given that we've spoken about this so many times since, I think since my first VROMI committee meeting in July, I think at this stage someone would have come knocking on my door and raided my jockey draw if I had done something which was illegal. So, I think it goes on to the next question again, which I hope to really have laid to rest. The third question of the MP was the land issuance of Maho classified as a reissuance or an extension? Madam Chair, through you, as stated on several occasions, Maho is classified as a reissuance. Again, I hope after 7 months and several instances of answering this question, we can lay this to rest. What is the status of the ongoing investigation into the issuance of government land, particularly regarding the cadastral records and pending cases? We have asked this question to the cadaster, and we await confirmation of this information. With your indulgence, Madam Chair, for the MP, if we can provide this in writing, once we get that answer, we will be much appreciated. Since when has favoritism in land allocation been an issue, and what measures are taking place to prevent it moving forward? This has been indicated for several times for several decades. There's no administration in particular where this is targeted to. It's across several and many. And the creation of land policy, of course, will prevent this favoritism from happening going forward. How will the government ensure that a new land policy corrects past injustices and promotes fairness for all applicants? As stated in the presentation, this policy actually addresses creating fairness under several ways, and I can repeat them again. Mandatory transparency and competition, strict conditions for exclusive land or sale, as two of those things which actually ensures that injustices are stopped. Regarding, of course, I think going back to the MP's question on the legal advice of structures that are built that are being renewed, let me just clarify as well. There's a policy in place that basically says that government land cannot be sold if there's no construction development on it. What has happened in the past is that people have been issued government land and they speculated. So they pay 1,000 guilders, 3,000 guilders every year. They turn around and sell the government land for hundreds of thousands of dollars. Since taking office, I have had one request to sell land like that, and I've said no. Because once there's no structure in place, you cannot sell the land because you're speculating. You haven't invested as required by law. Again, why are land policies in place? When it comes to the question about existing structures and its renewal, what's important to distinguish here is that I think the MP's use of the DDAM in its implementation in the Netherlands is different than in St. Martin. Government doesn't sell government assets or land in the way that happens in the Netherlands. And in instances of you saying to somebody that because you've invested a certain amount of capital into developing a property, and then you are not allowed, therefore, to have that property after 60 years, you basically, as government, become or can be considered a bad business partner. Because what you're actually asking government to do by stating that because someone can develop a piece of land and not be able to get it back, it means that then there's no incentive to actually develop government land at all, because what's the guarantee to actually be afforded to keep your investment. Government can, of course, take back government land. It is legally possible. We have to pay out the value of that development. So I think you can argue and say, in theory, what happens in the Netherlands is, yes, the Dutch government does publish land and its value, open to purchase. On St. Martin, if someone wants to purchase purchase or an investment, they have to go to someone willing to sell their investment. So if government starts now appropriating people's investments and don't pay for it or can't pay for it, and because we have to just reissue it and then give somebody else, that makes any investment in government land or any development of the person not attractive and makes government a very bad business partner. And for that, Madam Chair, that is the end of my, if I've missed anything, let me know. But I think we've come to the end of the questions.
Thank you, Minister Gums. Members of Parliament, of course, now you have the opportunity to ask any clarification that you would like the Minister to explain from what he said or the answers given. Is there anyone who requires the floor for clarifications at this time? I see no one having the need for that. I just would like to remind the Minister of we do have someone? Yes, we have MP York. Before I remind the Minister what I was going to remind him of, I give the floor to MP York for clarifications. MP York.
Thank you, Madam Chair. Once again, good afternoon to everyone. Minister, I remember you answered the question on the map, my map query. I just didn't get the part of what the real plan was. Maybe I missed it, but if you can clarify that for me. Upon the question of encroachment and people going over the bounds, especially as it pertains to public property, the Minister, through you, Madam Chair, alluded to the fact that steps will be taken by the Ministry. I would like to know if the Minister can explain what these steps are. So go down the list of specifics. What does the Ministry do in those situations? And as well, the Minister, through you, Madam Chair, referred to the old or the current building code, which is from the 20s, 30s, very old. But I remember prior to the Minister entering office, under the old Minister, I know they were working on a new building code. Because I know there was a whole craze, everybody wanted to submit the drawings before the new one would be implemented, and then everything went quiet. So is there a reason why the new building code was never implemented? I don't know, is there a problem with it? Is it still being worked on? What is the status as it pertains to the old building, or the new building code, or the pending one, I would say? And that would be, and the last question would be, the Minister agreed with the fact, through you, Madam Chair, that old requesters or requesters, period, would be the rightful thing to do to keep them updated throughout the process. But what would be the timeline into making something like that possible? A database or a system for that in the Ministry. So if you could have a kind of a deadline, not deadline, but a timeline, a tentative one, hey, within a year, within 2 years, within 6 months, that something like that could be possible. That also when it comes to permits, land issuance, all those type of things, when it comes to a waiting list, that people are kept up to date with their status. Yes, that would be it. Thank you.
Thank you, MP York. I think in terms of clarifications, that is it, Minister. So I just give you a moment while I think you are looking for the answer given. And Minister, are you ready to respond? You could have a minute or two if desired. Okay, so we'll just adjourn for 2 minutes. Yeah, meeting just adjourned while the Minister collects his notes. Members of Parliament, ladies and gentlemen, welcome back. At this time, the Minister will respond to the few matters that were asked to be clarified by members of Parliament, so I immediately give him the floor. Minister, you have the floor.
Thank you, Madam Chair. There was one clarification request regarding what happens in encroachment, what exactly the government does. When the Department of Domain Affairs finds out such has happened, during, for instance, a change of purpose or a transfer, the said change or purpose of transfer cannot proceed until the situation has been corrected. Most of the time, this results in an extension of land where the encroachment is. This is standard, done with 5 years retroactive effect. If not allowed, then of course there's a request to remove whatever has been built. Unfortunately, as much as I would want to do the Ministry and Department of Domain Affairs does not have the capacity to look into this kind of situation on a project basis. The question regarding why the building code delay, in short, we are experiencing some legal issues with the text that was provided, and we're working, of course, to rectify those as soon as possible. The MP had a final clarification regarding what exactly is being looked into for updating within the LiDAR aerial imagery. This is the basic layers. So we have a 2021 map, but of course we have to look at clarification.
MP York, we really don't have the opportunity. It's either that you need to find out something. Do you have interruptions left that you then can, then it would have to be a proposal of order or, okay. You sure you don't want to use the interruption and just, you have no more left? It's okay. Okay. Minister, you may continue.
What I can do and propose, Madam Chair, that then following the meeting, I will caucus with MP York, and I can clarify whatever publicly in the next press briefing. Yeah.
Thank you, Minister, and
no
you
problem.
may proceed.
I think that was it for clarifications. Yes, and regarding the timeline for the implementation of a tracking system, that information I cannot provide necessarily because I don't want to be necessarily giving information I can't uphold to. We are, of course, discussing how to digitalize currently. We have had smaller steps in terms of enhancing communication because, of course, it's currently done manually. As soon as I do have something a bit more concrete, I will, of course, come back to Parliament and update them in due course as the project continues. And with that, Madam Chair, I think I've covered any other clarifications that have existed. If not, let me know. Thank you.
Thank you, Minister, for those responses. Minister, if you can just confirm for me for this meeting, I have understood that there are actually 2 documents that you have promised to send. Is that correct? The one with the notaries, what is at the notaries, and then one for cadastre, one with the answers which you have to get from cadastre. So I just want to note these down as 2 documents that will be sent to Parliament as a follow-up to this meeting, because by noting that, we can then close off this public meeting of Parliament with that understanding that those 2 particular documents will be forwarded to Parliament following this meeting and as soon as you can. So, Minister and support staff, with that, I want to thank you for your presence and for responding to the queries and questions of members of Parliament. Members of Parliament, I want to thank you for your participation in this meeting. And ladies and gentlemen, those of you who are tuned in, thank you for your interest in meetings of this House of Parliament. With that, with our thanks going out to all concerned, I will hereby close this public